My name is Parna Mehrbani. I'm a partner here at Tonkin. I'm the co-chair of our firm's intellectual property practice group, as well as our IT and data security practice group. This is our webinar on the California Privacy Rights Act of 2020. Joining me is my colleague, Alexandria Wagner-Jakubiak.
Okay, so what is really new, especially if you have spent some time with the CCPA and complying with it in the past? We mentioned that 50,000 to 100,000 change in the covered organizations threshold, but there's plenty of other things. We're only going to focus on some of the key highlights. For example, covered entities actually has a few other ways that it expands its reach to other companies that may be associated with a company that is collecting information, and we'll talk about that in a moment. There's also a new category of personal information called sensitive personal information, and along with that new category, which is really a subset of PI, there's going to be new rights that consumers have and new rules regarding notification of when you're collecting that kind of data. There's going to be a few new consumer rights that Parna will go over, as well as expanded rights that already existed, but they're going to have a little bit more of a burden on the business side. Okay, so like I said, the covered organizations where you meet that first test that you're a for-profit business that collects, shares, or sells California residents, plus you meet one of the three thresholds that we talked about, the gross revenue and whatnot. You are also going to be responsible if you are an entity that is owned by or shares common branding with a covered business. So even if you are not the business doing the direct collection, you could potentially have responsibilities under this statutory scheme. However, there is an exemption for the related businesses, so long as the related business is not also sharing the information. It will be mostly exempt from all of this. So it's really important that you know what's going on with related businesses you own, you share branding with, and whatnot. Additionally, it's going to reach joint ventures and partnerships where you own a 40% interest in the entirety of either of those things. And really, this is for the purpose of enforcement. The agency, when it starts enforcing, will be able to look at one of those owners and consider them just as responsible as the other owners. And lastly, there are going to be some contractual obligations we will want to be thinking about when any third party is going to use the data that we collect, whether they use it, share it, sell it. There are going to be contractual obligations that need to be in place between a business and that third party. So SPI, the new category, which is really just a subset of personal information. It includes some new stuff. You'll see some overlap. Interestingly, I wanted to point out that biometric information has been added to SPI. That includes like a fingerprint. We think Apple phones, we often unlock with a fingerprint or through the facial recognition. If an app that you're using is going to use that data and hold that data, that's going to be considered sensitive personal information subject to new rules. You'll see some other things here. Social Security, precise geolocation data is data within a certain circumference. It's like a little over 1,300 square miles. If you're able to pinpoint where the consumer is in that radius, that specific information is going to be sensitive. Special rules related to this is that the consumers are going to be able to restrict a business's use of that data much more than they could restrict the use of PI. The next thing is that there are collection notifications. So at time of collection, usually this is addressed in a privacy policy or when someone signs up for a program or on your website, and they have to supply that information. At the time that they supply the information, the business has a duty to tell the consumer what they're using that information for, why they collect it, and how long they'll hold that information for, and a business can only hold it for as long as reasonably necessary, which is going to be a kind of a, there's going to be arguments on both sides about what is reasonable. But if you can tie it to a legitimate purpose of what you're doing business for, there's a good chance that it's going to be reasonable. And then lastly, there's going to be expanded notification requirements for personal information in general, including the retention period. So it's important that we update privacy policies to include that information. All right, Parna.
Thanks, Alex. Okay, so I briefly mentioned this earlier, but employees are no longer exempted under the CPRA. And this is a little bit of a challenge for businesses to sort of comprehend, because obviously we're going to talk in a little bit about California consumers having the right to request that you delete information, et cetera. And that seems kind of at odds with, well, I have to keep employees' information for lots of different reasons, right? So California employees, applicants, emergency contacts that you have for your employees, beneficiaries. Again, all of these folks they have the same rights as any California consumer. So you may need to consider if you're collecting different information from employees than you are from everyone else that you do business with, which very likely is the case. You may consider if you need a separate privacy notice under California law for your California employees, rather than pulling them in under your public privacy notice, which is very likely on your website. So what are the consumer rights? The first is the right to delete. California residents have the right to request deletion of any or all of their personal information. Sorry, I lost my slide here. Let me get back to the right place. This can include, consumers can now also request that businesses instruct third-party vendors, service providers, and contractors to also delete any personal information that the business may have given to those third parties. There are a few exceptions to the right to delete. Common reasons why you may be able to keep personal information, even if you get a right to delete, are that you can't verify the identity of the consumer that sent in the right to delete request, that you need the information to complete a transaction with that consumer, to provide a reasonably anticipated product or service, or for certain warranty and product recall reasons. You can also keep information for certain business security reasons, for certain internal uses that are compatible with the consumer's expectation in the context for which they gave you the information. And you can also keep information to comply with legal obligations, exercise legal claims or rights, or defend legal claims. And then as a reminder, there's certain personal information that's exempt from the California law, which includes information like medical information that's already governed by the HIPAA law, consumer credit reporting information, and then other types of information that are exempt from the California law. Another right that consumers have is the right to access. So a business must provide all personal information data if they get a request from a consumer to access the information that business has. And this now includes providing the consumer information, again, about the businesses that you have shared the information with. And a new provision is that you now have to name the third parties who you've shared the data with, even if those third parties are just like vendors that you'd use in order to conduct your business. Another consumer right is the consumer's right to opt out. And that right has been expanded to not only allow California residents to opt out of the sale of their personal information, but also to opt out of a business's sharing and selling personal information specifically for behavioral advertising. Again, there are some exceptions to this opt-out right. Common reasons that you can refuse to stop selling or sharing include that, again, the sale or the sharing is necessary for you to comply with legal obligations, exercise legal rights, or defend legal claims. And then again, if it's information that's exempted from the CCPA, so publicly available information, certain medical information, or other types of information that are exempted. A new right under the CPRA is the right to data portability. So a California resident can request to have their personal information transported to other businesses or organizations. This sort of comes down to a format request. So consumers can request to get their data from you in a certain format that it can be sent to another business or organization. Another expanded consumer right is the consumer's right to know what personal information is collected. This used to be limited to just the past 12 months, so what you've collected in the past 12 months. And that is no longer a timeline. That's no longer a restricted timeline. Again, there are exceptions to this. There's some common reasons why businesses may refuse to disclose personal information under a right to know request are that the business cannot verify the consumer that made the request is who they say they are. The request is unfounded or it's excessive, or you've already provided that same consumer personal information more than twice in the last 12 months. You also cannot disclose certain sensitive information, such as social security number, financial account numbers, passwords, but you can tell the consumer that you have that type of information and that you are collecting that type of information. Other reasons that you may not disclose is that disclosure would restrict your ability to comply with legal obligations, exercise legal rights, or defend legal claims. And again, if the information includes data that's not covered under this law. There are also some new consumer rights under the CPRA. The first includes a minor's right to opt in. So while everybody else gets to opt out, minors who are under the age of 16 have to opt in to selling or sharing of their personal data. This was in the CCPA, but in the CCPA, so the earlier law, the right to opt in only was if you were selling the data. Now, minors have to opt in whether you're selling or sharing the data. So it's expanding the protection for minors. And once a consumer that is under the age of 16 has declined to provide consent, you have to wait at least 12 months before requesting consent again, or you otherwise have to wait for that minor to turn 16, right? Then they're over that age restriction. Another new consumer right is the right to correction, which allows California residents to the right to request that inaccurate personal information or sensitive personal information is corrected. Similar to the right to delete, consumers can also request that you instruct any third parties, service providers, vendors, et cetera, also correct their information if you gave that third party the information. Legitimate requests from consumers have to be verified, and then you have to move forward with the correction within 45 days. And like the other rights, there are some exceptions. So some of these exceptions may include that you can't verify the identity of the person making the request. The request is manifestly unfounded or excessive, or again, the information is not covered by the law. So publicly available information, health information, et cetera. Two new rights under the CPRA are the right to know about automated decision-making. So California residents can request access to and knowledge about how a business's automated decision technologies work and the probable outcomes of using those technologies. The right to opt out of automated decision making allows California residents to opt out of their personal information and sensitive personal information being used to make automated inferences. And that includes profiling to evaluate certain personal aspects of a person, and in particular to analyze or predict aspects concerning that person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. So that is really a restriction on a lot of behavioral advertising. Okay, moving on to the next issue. So this is an upcoming children's privacy law in California. This one doesn't go into effect until July 1st, 2024. We expect this to be a little bit burdensome. So the California Age Appropriate Design Code Act was signed by Governor Newsom on September 15th of 2022, and it goes into effect July 1st of 2024. This law is going to require businesses that provide an online service, product, or feature that, and these are the key words, are likely to be accessed by children to comply with specified requirements, including strict default privacy settings, unless there's a compelling reason not to, and then clear communication of privacy information, and also a preemptive data protection impact assessment prior to introducing any new such online services, products, or features. These assessments have to be made available to the Attorney General. And the bill is going to create a children's data protection working group to report to the legislature in California on best practices. There's going to be the Attorney General is going to have enforcement authority, and there's going to be potential injunctive relief, civil penalties per child for violations, and they're higher for intentional violations. I think it's worth noting that Oregon has a Senate bill. It's still in the bill phase, but it is modeled after this law. It's in the Judiciary Committee, and Virginia is also contemplating these issues.
Okay. Well, lastly, that brings us to the cybersecurity audit and risk assessment burdens. And so these are going to be things that we're going to get more specificity on when the regulations come out towards the end of the month, when we know more information. But essentially, the point behind this is if you are storing any personal information or sensitive personal information that could put or present a significant risk to a California resident's consumer privacy, or if it could put the data at security risk, your business is going to be required to perform an annual cybersecurity audit and submit it to the new agency that is being formed and will start enforcement on July 1st. In order to kind of see if you might need this cybersecurity audit, there's also this risk assessment process. The risk assessment has no exemptions. Every covered organization that meets the tests that we talked about earlier is going to be required to conduct these risk assessments. Right now it says regularly. We suspect that's going to be an annual requirement, but we will learn more at the end of the month when we get more information from the regulations. Essentially, the risk assessment, you need to take a look at all of the data that you process and weigh it against the risks of a consumer's privacy or security being at risk and the benefits of what you're using the data for. It's pretty amorphous at this point, but it's really important to start thinking about if you have risk assessments in place, if you're evaluating what data is coming into the business each year, that is a great starting place.
So we're going to stop there. And I do just want to reiterate that when there are going to be regulations coming out in California, And our goal is to continue to update you on this information and give you updates on those regulations as well.